Hello, everyone, and welcome to this Federalist Society virtual event. My name is Marco Lloyd, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host a FedSoc Forum webinar, a religious charter school, a discussion on the limits of state action and demands of the Free Exercise Clause, featuring Alex Luchenitzer and Philip Seckler. Our moderator today is Michael Moreland. Dr. Moreland is a university professor of law and religion and director of the McCullen Center for Law, Religion, and Public Policy at Villanova University. His full bio can be viewed on our website, fedsoc.org, along with the bios of all of our accomplished speakers. If you have a question at any point in today's program, please enter into the Q&A function at the bottom of your Zoom window, and we'll do our best to answer as many as we can. Finally, I'll note that, as always, the Federalist Society takes no position on particular legal or public policy issues, and all expressions of opinion are those of the speakers. With that, Professor Moreland, thank you for joining us today, and the floor is yours.
Thank you, Marco, and thanks as always to the Federalist Society for putting on these informative and balanced discussions of controversial topics of the day. As Marco mentioned, today we're talking about religious charter schools. On June 25th, 2024, the Oklahoma Supreme Court ruled that the nation's first religious charter school, St. Isidore of Seville Catholic Virtual School, was unconstitutional under the Federal Establishment Clause based on the Oklahoma Supreme Court's view that the privately operated school was both a government entity and a state actor. This finding of state action also led the court to uphold a state law that expressly bans religious entities from operating charter schools. This forum will present views from litigation counsel on both sides of this historic case. Our panel will explore the arguments for and against the religious charter school in Oklahoma, including whether the charter school can fairly be considered a state actor and whether the Free Exercise Clause prevents the state from discriminating against religious operators in a public program that encourages private innovation in the formation of charter schools. And to discuss that, we have two excellent speakers, as mentioned, counsel as well in the case. I will give short introductions to them. Their full bios, as Marco mentioned, can be found on the Federal Society website for this webinar. First, Alex Luchenitzer is Associate Vice President and Associate Legal Director of Americans United for Separation of Church and State. And Phil Seckler is Senior Counsel at the Alliance Defending Freedom. Our speakers will provide opening statements for about 12 or so minutes each. Then we'll have some discussion among the panelists. And finally, we'll take questions from you, the audience. And as Marco mentioned, you can submit your questions at the Q&A box at the bottom of the Zoom screen. And with that, I will turn it over for an opening statement to Phil Seckler.
Thanks, Michael. It's a pleasure to be here. And in fact, the Oklahoma Supreme Court issued a ruling in the Drummond case in June of this year. It was only a year before that ruling that the statewide virtual charter school board of Oklahoma approved St. Isidore, a Catholic virtual school, to be the 8th statewide virtual school in the state. But as you said, in June, the Oklahoma Supreme Court rescinded that approval on grounds of the Establishment Clause, the Oklahoma Constitution, and a provision in the Oklahoma Charter Schools Act that prohibits charter schools from having a religious program or even being affiliated with a religious group. Our cert petition in that case is now due on October 7th. You might be wondering how a state board approved St. Isidore as a charter school if Oklahoma law prohibits religious charters. Well, Oklahoma's former Attorney General, John O'Connor, issued a formal opinion to the board explaining that Oklahoma's non-sectarian requirement for charter schools was likely unconstitutional and should not be enforced. And this is what he said, quote, "The state cannot enlist private organizations to promote a diversity of educational choices and then decide that any and every kind of religion is the wrong kind of diversity. That is not how the First Amendment works." So today, what I would like to do is explain why the First Amendment requires Oklahoma to open up its doors and its charter school program to St. Isidore. And in so doing, I will touch on the Free Exercise Clause, the Establishment Clause, and the State Action Doctrine. So first, under the Free Exercise Clause, a state may not open a public benefit program to private groups, but exclude religious groups from participating. That's clear. The Supreme Court made it clear in 3 recent cases, Trinity Lutheran, Espinosa, and Carson versus Macon, which are now referred to as the Free Exercise Trilogy. And in fact, two of those cases, Espinosa and Carson versus Macon, involved public funding of education. Each of these cases states that discrimination by the government on the basis of religion is odious to our Constitution. And that's because it places an unlawful condition on participation. You have to renounce your faith to participate in the program. And that's exactly what Oklahoma law does. Its charter school program invites private groups to bring new and different approaches to educating students. Once approved, the operator of the school enters a contract with the state to educate students in return for tuition payments from the state. But if you're religious, you cannot participate. That's the kind of religious discrimination the Supreme Court calls odious. And any law that excludes an organization from a public benefit program on grounds of religion is subject to the strictest scrutiny, which of course requires a compelling state interest. And here's the clincher. Separating church and state more fiercely than the Establishment Clause requires cannot be a compelling state interest when free exercise rights are at issue. The Supreme Court has repeatedly made that clear. So if a state decides to open a charter school program to private groups to encourage innovation, it can at the same time exclude religious groups unless that exclusion is necessary to avoid violating the Establishment Clause. And so that brings me to my second point. The operation of St. Isidore as a charter school would not violate the Establishment Clause. And three things about St. Isidore make that crystal clear. First, St. Isidore is privately owned and operated. Second, the approval of St. Isidore as a charter school was neutral toward religion. Oklahoma law certainly doesn't promote or favor religion, and the charter school board determined it could not be hostile to religion. In other words, St. Isidore's application was treated the same way any secular group's application would be treated. And third, money will flow to St. Isidore only if parents choose it. Every dollar that St. Isidore receives will be tied directly to the independent choices of families and parents. And the law on this has been clear for many years. A neutral benefit program that directs funds to religious schools based on the independent choices of private citizens does not offend the Establishment Clause. So how on earth did the Oklahoma Supreme Court, in a 6-2 ruling, reach the opposite conclusion, that operation of St. Isidore as a charter school would violate the Establishment Clause? Well, it considered St. Isidore to be both a government entity and a state actor. And that leads me to my third point. St. Isidore is neither a government entity nor a state actor. On those issues, the Oklahoma Supreme Court got it completely wrong, and that led it to a wrong answer about St. Isidore. Let's start with whether St. Isidore is a government entity. Here are the undisputed facts. St. Isidore was incorporated as a nonprofit corporation by two private members. It has its own certificate of incorporation and its own bylaws. It has its own board of directors who are private citizens who are all privately appointed. It has its own employees who report to the board. They are not public employees. It has its own assets, its own facilities, and its own bank accounts. In short, the government did not organize and does not own St. Isidore. And the whole point of charter schools is to have private actors provide alternatives to government-run schools. So that's why St. Isidore, also under the law, is responsible for its own program of instruction, its mission statement, its curriculum, its teaching methods, its educational environment. It designs all of its own policies, its personnel policies, its discipline policies, and its student code of conduct. And it makes all of its own operational decisions. In short, the government doesn't operate St. Isidore. St. Isidore is freed by design from the constraints of government to foster innovation. That's what the Charter School Act says. The purpose of the act is to, quote, encourage innovative teaching and, quote, establish new forms of accountability. Imagine the consequences if charter schools were government actors. A host of constitutional obligations would overrule many policy innovations, like single-gender schools, dress codes, and strict discipline. the school's operational decisions would be routinely challenged for lack of due process, and plaintiffs' lawyers would bring 1983 suits against charter schools and drain them of resources, including by seeking payment of their attorney's fees under Section 1988. Declaring charter schools to be government entities would defeat their very purpose. Now, our friends on the other side like to focus on the fact that the Oklahoma statute refers to a charter school as a public school, but they rarely mention the entire statutory phrase, which is, quote, public school established by contract. They also don't mention that the term public school is expressly defined under Oklahoma law simply to mean a publicly funded school. It doesn't mean a government-operated school, which is what they want you to imagine. And in fact, the Supreme Court has repeatedly held that the term public doesn't mean government, holding that public utilities, public defenders, and even public access television operators are not state actors. The relationship between Oklahoma and St. Isidore is clear. It's simply one of contract. There is no charter creating St. Isidore. As I said before, it was privately organized. It is a contractor with the state, just like a hospital, a nursing home, or an orphanage that provides services to the state. The most that can be said about the state's role in this is that the state law does authorize the contract to be entered. But the act also expressly recognizes that the contract is being entered between the state and a private actor. So because the state did not organize, does not own, and will not operate St. Isidore, there is no world in which St. Isidore can properly be considered a government entity. That takes us to the state action doctrine. And on that, I'd like to make 3 points. First, no matter which test is applied, the state action inquiry always seeks to answer the same core question, which is whether specific conduct can be fairly attributed to the state. So any state action analysis has to consider the particular acts at issue and whether they are fairly attributed to the state. What are the acts at issue here? Offering a religious curriculum and operating according to the Catholic faith. What was the state's involvement in those decisions? Nothing. The state did not encourage or even suggest to St. Isidore that it operate according to its faith. That was entirely St. Isidore's decision. Thus, there is no basis for attributing St. Isidore's religious character to the state, and the analysis can end there. Second, federal appellate courts, for the most part, have been clear. Privately operated schools that educate children under contract with the state are not state actors. Indeed, that's what the Supreme Court held in Rendell Baker in 1982. That case involved a school for troubled youth. Nearly all of the students were referred to it by the state. It was subject to extensive state regulation, and it received up to 99% of its revenue from public funds. Nevertheless, the Supreme Court held the school was not a state actor because the state didn't compel or encourage the employment decisions at issue, and because educating children whom the state had an obligation to educate was not a traditionally exclusive public function. So when you hear my friend on the other side recite the many regulations Oklahoma has in place for charter schools, ask how that's any different from the many regulations on the school in Rendell Baker. You might also hear him argue that a contractor who performs a function the state has an obligation to perform is a state actor. That's not true either, and Rendell Baker says so. The Ninth Circuit easily applied Rendell Baker to find an Arizona charter school was not a state actor, notwithstanding the same public school label. That's the Cavanis case. And similar results involving schools operating under contract with the state were reached by the First Circuit and the Third Circuit in an opinion written by then Judge Alito. The outlier is the Fourth Circuit's Peltier case, which ignored Rendell Baker, as the 6 dissenting judges there pointed out. My third point, the other side's attempt to distinguish Rendell Baker falls short. Principally, they argue that that case concerned education, whereas a charter school delivers public education, and that's the exclusive public function. But in 2019 in Hallett, the Supreme Court rejected a similar attempt to recast the function at issue because it ignored the threshold question and was outcome determinative. And that's the same argument the other side makes here. And in Carson versus Macon itself, Maine attempted to argue the free exercise clause didn't apply because what it was offering was public education. The First Circuit actually bought that argument, but the Supreme Court rejected it, viewing it as a semantic exercise which could not justify an infringement of free exercise rights. The other state action argument that has been made is the entwinement test, but not a single member of St. Isidore's board is a public official, and no public official is running the school. There's literally no entwinement under the Supreme Court's test. So this is all a far cry from state action, and it's even a further cry from showing that a state violates the Establishment Clause by operating a charter school program that is entirely neutral toward religion. And without an Establishment Clause violation, Oklahoma's exclusion of religious groups from its charter school program necessarily fails strict scrutiny. So let me conclude by saying this case matters a great deal. It matters because the government should not be discriminating against religious groups in its administration of public benefit programs. It matters because parents are better off with more school choice, including schools that align with their faith. And it matters because charter schools, which are designed to foster innovation, should not be subject to the same governmental constraints that inhibit innovation in the first place. Thank you.
Thank you, Phil Seckler. And with that, I will turn it over to Alex Luchenitzer for a rebuttal.
Thank you, Michael. Thank you, Phil. I'm going to cover three main points in my opening statement. First, the Oklahoma Supreme Court's decision was correct. Charter schools are public schools, governmental entities, and state actors. For that reason, they have no federal constitutional right to teach a religious curriculum in violation of state law. Second, in arguing that charter schools are not bound by the U.S. Constitution, St. Isidore is seeking a radical change in the law. Virtually every court to consider the question has concluded that charter schools are governmental entities or state actors. Third, if St. Isidore succeeds in its quest to obtain a U.S. Supreme Court decision that charter schools are not state actors and that religious charter schools are legally permissible, the outcome would be harmful both to religious freedom and to the school choice movement. Religious institutions that operate charter schools would face government oversight that would threaten their religious autonomy. And charter schools would become less attractive options to parents because students attending them would no longer have constitutional protections against improper actions by the schools. I'll start off by explaining why the Oklahoma Supreme Court's ruling was right. Oklahoma's Constitution and Charter Schools Act prohibit charter schools from teaching a religious curriculum. St. Isidore's main argument in the litigation is that the federal free exercise clause overrides these state law restrictions, as Phil explained. But that contention fails because charter schools are governmental entities and state actors. As a governmental entity, St. Isidore does not have free exercise clause rights that it can assert against the state of Oklahoma. And even if St. Isidore could assert free exercise rights, it must comply with the Federal Establishment Clause because it is a state actor, and state actors are bound by the U.S. Constitution. The Federal Establishment Clause prohibits state actors from inculcating children in a particular religious faith, as St. Isidore would. The U.S. Supreme Court has used several tests to determine whether private entities are state actors, such as the public function test, the symbiotic relationship test, and the nexus test. But the Supreme Court has also made clear, in a decision authored by Justice Scalia called LeBron versus National Railroad Passenger Corporation, that these tests are inapplicable when a court determines that the entity at issue is a governmental entity. When a court does so, that inherently renders the party a state actor, and no further analysis of whether the party must comply with the Constitution is needed. For example, without applying the state action tests that are used for private entities, the U.S. Supreme Court and federal circuit courts have concluded that state universities and colleges, public hospitals, state judges, prosecutors, state bars, and Amtrak are all governmental entities. Indeed, earlier this year, in a case called Linkey versus Freed, the Supreme Court unanimously reaffirmed this principle, stating, quote, courts do not ordinarily pause to consider whether the Constitution applies to the actions of police officers, public schools, or prison officials. And here, as public schools, Oklahoma charter schools are governmental entities and state actors. Oklahoma charter schools are defined as public schools by a state statute. And charter schools in Oklahoma have numerous other characteristics in common with traditional public schools that confirm that they are governmental entities. They must be as equally free and open to all students as traditional public schools. They must comply with all laws relating to the education of children with disabilities in the same manner as a school district. They must not charge tuition or fees. They are subject to the same academic standards and expectations as existing public schools. They receive state funding in accordance with statutory requirements and guidelines for existing public schools. Like all other public schools, Oklahoma charter schools must annually submit accreditation applications to the Oklahoma State Department of Education. Oklahoma charter schools must also comply with the same rules that govern traditional public schools on school year length, bus transportation, student testing, student suspension, financial reporting and auditing, and insurance coverage and fidelity bonding. Employees of Oklahoma charter schools are eligible for the same retirement benefits that Oklahoma provides to teachers at other public schools, and for the same insurance programs that are available to employees of the governmental sponsors of the charter schools. Oklahoma charter schools must comply with the Oklahoma Open Meeting Act and the Oklahoma Open Records Act. They are eligible to receive current governmental lease rates if they choose to lease property. They must have governing boards that hold public meetings at least quarterly and that are subject to the same conflict of interest requirements as a member of a local school board. Each Oklahoma charter school is considered a separate local education agency, which is a term that is defined by federal law as a public board of education or other public authority legally constituted for administrative control or direction of public schools. Oklahoma charter schools are considered school districts for purposes of tort liability under the Oklahoma Governmental Tort Claims Act. And the Oklahoma Judicial Ethics Advisory Panel recently determined that service on the board of an Oklahoma charter school would be considered an appointment to a governmental committee, board, commission, or other governmental position. But even if Oklahoma charter schools are not governmental entities themselves, they are still state actors under tests that are used to determine whether private entities are state actors. Because my time is limited, I'll just give one example of that. As the Supreme Court reaffirmed in a 2019 decision authored by Justice Kavanaugh, Manhattan Community Access Corporation versus Halleck, which Phil also mentioned, a private entity is a state actor when the government has outsourced one of its constitutional obligations to the entity. Several provisions of the Oklahoma Constitution obligate the state to provide free public education. As Oklahoma charter schools perform a duty that the state is constitutionally mandated to perform, the provision of free public education, they are state actors. Because St. Isidore is a governmental entity and a state actor, the U.S. Constitution's Free Exercise Clause cannot override the provisions of Oklahoma law that prohibit charter schools from teaching a religious curriculum. Indeed, because St. Isidore is a governmental entity, it has no rights under the Federal Free Exercise Clause to disregard any provision of state law. As the Supreme Court reaffirmed in a 2009 decision authored by Chief Justice Roberts, Usursa versus Pocatello Education Association, subordinate units of government do not have any rights under the U.S. Constitution that they can assert to challenge the laws or regulations of the states or state entities that made their existence possible. Here, St. Isidore was able to become a charter school only as a result of state legislation that created charter schools and the grant of a charter by a state board. As a subordinate governmental body in Oklahoma, St. Isidore cannot assert federal constitutional claims to challenge Oklahoma constitutional provisions or statutes. But even if St. Isidore could rely on the federal free exercise clause to challenge the provisions of Oklahoma law that prohibit charter schools from having a religious curriculum, its free exercise clause arguments would fail. That's because compliance with the U.S. Constitution's Establishment Clause is a compelling governmental interest that satisfies any level of scrutiny under the Free Exercise Clause. In other words, the Federal Free Exercise Clause cannot require what the Federal Establishment Clause prohibits. And the Federal Establishment Clause bars public schools and other state actors from presenting religious instruction or requiring children to engage in religious activity. Yet St. Isidore, despite being a governmental entity and a public school, plans to do exactly that, including by mandating that its students take theology classes and by integrating religious doctrine into otherwise secular subjects. For these reasons, the three main free exercise clause cases that Phil emphasized, Trinity Lutheran, Espinoza, and Carson, are inapplicable. All of the religious schools at issue in those cases were private schools. None of them were governmental entities or state actors. And so, unlike here, participation by those schools in the governmental programs at issue would not have resulted in a violation of the Establishment Clause. And let me go on to my second point. The arguments that religious charter schools should be permissible, thus, are not supported by existing law. Indeed, they seek a radical change in the law. St. Isidore's arguments hinge on the assertion that public charter schools are not state actors, but virtually every court to consider that question has concluded that charter schools are governmental entities or other state actors. There are at least 23 decisions to that effect. And while most of those decisions were district court ones, federal appellate panels from at least 4 different circuits have treated charter schools as governmental entities or other state actors. On the other hand, no federal appellate court or state Supreme Court has ever concluded that a public charter school is not a state actor with respect to the performance of its educational functions. One Ninth Circuit panel, which is the Kavanaugh case that Phil mentioned, that case did hold that a charter school was not a state actor with respect to its employment decisions. But as Phil also mentioned, an entity can be a state actor for some purposes, but not others. And that case did not address whether a charter school's delivery of its educational programming is state action. And all the other Supreme Court and appellate state action cases addressing schools that Phil mentioned or that St. Isidore has cited in the litigation, all those cases involved private schools, not charter schools. For example, the school in Rendell Cohen versus Baker was a private school, not a charter school. And what's more, as I noted earlier, the Supreme Court reaffirmed only 6 months ago in the Lindke case that public schools are considered state actors. If St. Isidore is somehow able to convince the court to abandon that conclusion and issue a ruling that public charter schools are not bound by the U.S. Constitution, that would create enormous uncertainty about whether other institutions that have long been thought of as governmental entities, such as public universities and public hospitals, are indeed state actors that must comply with the constitutional requirements. Officials who administer those institutions would face great confusion over what legal obligations apply to them, and people served by those institutions would suddenly no longer know what rights they have. And now let me conclude with my third main points. So, if St. Isidore succeeds in its efforts to obtain a Supreme Court ruling legalizing religious charter schools, that outcome would be detrimental to both religious liberty and the school choice movement. As I explained earlier, charter schools in Oklahoma must comply with a host of legal and regulatory requirements, and other states typically impose similar rules. As a result, by operating charter schools, religious organizations would lose their ability to autonomously pursue their religious missions without governmental interference. For example, Oklahoma prohibits charter schools from discriminating in admissions on any ground and from discriminating in employment based on grounds that include religion. St. Isidore has made clear that it plans to discriminate in employment based on religion, and while it asserts that it will admit any student who wants to enroll, it maintains policies that would have the effect of excluding students based on religion, sexual orientation, and gender identity. Though St. Isidore's discriminatory policies and practices were not at issue in the Oklahoma Attorney General's lawsuit that went to the state Supreme Court, they are the basis of claims in a separate lawsuit in which I am representing the plaintiffs, among other counsel, that seeks to prevent St. Isidore from operating as a public charter school. Even if St. Isidore convinces the U.S. Supreme Court to reverse the Oklahoma Supreme Court's decision, we are optimistic that we will prevail on those discrimination-based claims in our case, because those claims do not depend on whether St. Isidore is a state actor, and because the claims are based on neutral prohibitions that treat religious and non-religious organizations equally, and that therefore are not susceptible to challenge under the Free Exercise Clause. Finally, if St. Isidore does convince the U.S. Supreme Court to take its case and hold that charter schools are not state actors, the ruling would also be harmful to charter schools themselves. Many parents send their children to charter schools instead of private schools because they believe charter schools to be bound by the U.S. Constitution and thus understand charter schools to be environments where their children's rights will be protected. But if the U.S. Supreme Court strips charter school students of all of their constitutional rights, charter schools will become much less attractive options to parents, and fewer students would be enrolled in charter schools. For the reasons I have just described, some Catholic educators, some charter school advocates, and some proponents of school choice, including the Cato Institute, have expressed great misgivings about St. Isidore's misguided endeavor to legalize religious charter schools. So, Michael, let me turn the discussion back over to you. I understand you have some questions.
Thank you, Alex. Yes, we'll have a little back and forth among the panelists now. And again, we'll try to save a good 15 minutes or so at the end for questions, which you are welcome to submit at the Q&A function at the bottom there. So, Phil, I'll turn it back to you. You can respond to anything that you'd like, but maybe in particular, I guess a couple things from what Alex said. One is the very in the weeds issues about Oklahoma state law and the status of charter schools in state law, and the extent to which, and this gets complicated very quickly, I know, but the extent to which that insulates the Oklahoma Supreme Court's decision from federal constitutional review because it turns on some questions of state law. So that might be one issue. And the other would be the points Alex made, which come up often in this debate about conditions that if, in fact, religious charter schools are permissible, the kinds of conditions that then the states could impose on them. It's happened, I think, in Maine already, post Carson versus Macon. The legislature has enacted some conditions on the recipients of the tuition scholarships there, and the extent to which you and folks on your side of the debate are worried about that possible turn of events.
Yeah, thank you, Michael. There really are no state law issues that need to be considered. Everything that Alex mentioned about state law is simply just the regulations that apply to charter schools. They're regulations. They're regulations that are not as extensive as the regulations the public utility faced in the Jackson case that the Supreme Court held was not a state actor. I mean, if you have an entity that was not organized, is not owned, and is not operated by the government, then there really is no world in which a regulation or a set of regulations can cause that entity to be a government entity. Just to take one, I won't go through all of the things he mentioned, but just take one example. He mentioned the Open Meetings Act and the Opens Record Act. So those acts apply to public bodies in Oklahoma. The legislature, when it enacted the Charter School Act, said, by the way, we want charter schools in their contract with the state to agree to those provisions. Now, of course, they wouldn't need to do that if charter schools were public bodies, right? So they had to actually do that in addition to what the Open Meetings Act and Open Record Act already says. And they do it by contract. It's basically a contract provision that helps with transparency of the school. So I don't think, Michael, there are any state law issues. And in fact, when you read the Oklahoma Supreme Court's opinion, even on this governmental entity issue, they cited two federal cases to support their, and only two federal cases to support their conclusion that this set of regulations facing charter schools means a charter school is a government entity. But I do think that, we agree that the free exercise issues and the correctness of the Oklahoma Supreme Court's ruling really does come down to whether or not St. Isidore can be called a government entity or a state actor. I think I addressed most of the state action points in my opening statement, except one that Alex made, and that's the outsourcing point. So, of course, government outsources obligations all the time, and the outsourcing doesn't make the contractor a state actor. In fact, in the Rendell Baker case, the Supreme Court said acts of private contractors do not become acts of the government by reason of their significant or even total engagement in performing public contracts. And as I said, Rendell Baker involved a contract for educating students that it was the state's obligation to educate. So that outsourcing bit that was mentioned deals with a case called West. And in West, the state essentially abandoned its own performance of a duty in terms of prison medical care and just outsourced it completely. Like it didn't do it at all. And of course, for charter schools, we know that the traditional public schools are still in existence. This is not a situation where a state has decided to close its public school system and privatize it all. So that line of cases really doesn't apply. The other question you asked, Michael, was about the conditions. So in the Espinoza case, Maine argued the exact same thing. It said, you know what? Actually, this is going to be, if we have to give these tax credit scholarships to religious schools, that's going to really threaten the religious liberty of the schools. And the Supreme Court rejected it pretty easily and said, you know what? It's up to the school. If the school wants to be part of that regime, it can be. If it doesn't want to, it doesn't have to be. It's completely up to the school. And then one final point, I think Alex ended on his point that, a ruling that a charter school is not a state actor or not a government entity means that parents who want their kids to go to schools that are protected by constitutional rights won't have them anymore. Well, there's an easy answer for that. Those parents can send their kids to a school that offers constitutional rights, either by way of being part of the government or by some contract promise to the parents. But certainly, it shouldn't be the case that the answer to that is imposing constitutional obligations on every charter school and all of the innovation that will be overruled by that.
Thank you, Phil. And again, Alex, anything you'd like to respond to or amplify? I did think maybe one question to consider is the extent to which in this post-Carson environment are there things that, if shown to be true, would mean that your side of the litigation would necessarily lose? In other words, to what end? For instance, you mentioned that the compliance with the Establishment Clause is a compelling interest. I guess I'm wondering, would there be arguments out there that the courts holding in cases like Kennedy versus Bremerton School District and others that have abandoned the Lemon Test, abandoned a lot of the Warren and Burger Court Establishment Clause precedents, have lowered the requirements for the state to have such a somewhat separationist view about the Establishment Clause, and that combined with the holding in Trinity Lutheran, Espinoza, and Carson, means that it, as a federal constitutional matter, your side of the argument has become more difficult, even if I acknowledge probably organizations such as yours aren't very happy with that trend in the case law. But anything else you want to mention as well, feel free.
Sure. So let me address the impact of Kennedy first. I mean, Kennedy does not mean that public schools are free to indoctrinate children in a particular religion or immerse them in a religious curriculum. And not even Phil's side or St. Isidore argues that. I mean, I think they agree that if St. Isidore is a governmental entity or other state actor, that they lose. Kennedy left undisturbed numerous cases that long preceded the Lemon Test, and that prohibited um, injection of prayer or religious instruction into public schools, such as the 1947 decision in McCollum uh, and the early 60s decisions in Engel versus Vitale and Abington School District versus Shemp. I mean, all those decisions preceded Lemon, and they were all based on historical analysis. And the court in Kennedy reaffirmed that um, courts need to look to the original intent of the founders of our nation in interpreting that Establishment Clause. And in the cases that have prohibited religious instruction and prayer in the public schools, the court actually did that. The court, very carefully and closely looked at the history of the abuses in the Europe and the colonies that led to the enactment of the Establishment Clause and the writings of the founders. And those made very clear that the government must not religiously coerce people and must not favor or promote any particular religion, and that therefore, based on those principles, in the public schools should not include religious instruction or any kind of religious mandates. And then, St. Isidore this doesn't hide that they would have a highly religious curriculum. They would have worship, mandatory worship and prayer sessions, and that they would present their operations like any other Catholic school does. So in terms of the impact of Carson and the Espinoza and Trinity Lutheran, as I explained, because here there is an Establishment Clause violation. If St. Isidore is allowed to operate as a public charter school, those cases just don't apply, because in all those cases the court concluded or assumed that there would not be an Establishment Clause violation. And also in those cases, the state restrictions at issue were clearly discriminatory against religious institutions. But here, in terms of the prohibitions on discrimination in admissions and employment that apply to Oklahoma charter schools and that St. Isidore does not wish to comply with, those are all religion neutral prohibitions. So, Carson doesn't apply the general rule of employment division versus Smith applies, which is that if a prohibition is generally applicable and neutral with respect to religion, then it does not trigger heightened scrutiny under the Establishment Clause. And finally, just kind of like one point going back to the state action issue. Essentially, St. Isidore's arguments are that it's a private public school. I mean, and that's that's an oxymoron. There's no such thing. And while the Charter Schools Act exempts St. Isidore from some statutes and requirements that apply to traditional public schools, numerous other requirements, that many of which I mentioned in my opening presentation, remain in place. And so, St. Isidore and other Oklahoma charter schools remain governmental entities and state actors.
Great. Well, thank you both, and we'll continue to bounce back and forth between our two panelists, but maybe we could take some time now for some questions from the audience, again, you're invited to submit a question on the Q&A function at the bottom of the Zoom window. So here's a question to Phil. It's a little long, but I'll try to shorten it. On your second point against the application of the Establishment Clause, you state that approval was neutral toward religion. In the majority opinion in Drummond, that's the Oklahoma Supreme Court's opinion, they highlight the differences between the model contract provided to the charter schools and St. Isidore's contract, including removal of the non-secular provision and inclusion of the ministerial exception. With these differences and the approval by the board by 3-2, how can the board's approval still be considered neutral?
Yeah, thanks for the question. So essentially, when the board entered the contract with St. Isidore, they had to take the model contract and change it because the model contract included the non-sectarian provision in the statute. So of course, because they decided that they could not, in good conscience, apply that non-sectarian provision to exclude St. Isidore because it was Catholic, they had to modify the contract as well. And in fact, the law, Oklahoma law, allows the board to come up with contracts that suit a situation. They are not required legally to follow a single model contract. So I think that answers the question. And neutrality, though, does kind of go back, Michael, to what you and Alex were talking about before, because I think that's where Kennedy puts us, which is, the government should have a neutral stance toward religion. And the reason why it's important for the other side of this case to argue that St. Isidore is a government actor is because that's where they have their argument that there's some faith-based incentives, right? Because the school is a Catholic school. They certainly have a Catholic mission. But from the government's perspective, you have to look at the Charter School Act. And the Charter School Act has no preference for religion. It treats a school for drama, a school for language immersion, a school for Catholic studies. I mean, all of these schools will be treated the same way, and they're not favored by the law at all. And that's why it's important. Because of that, there's no Establishment Clause problem with the program. And so the other side is trying to make the government be the school, which is clearly private, as I said. I don't think it's public school only because that's what it's called by the statute. But in her dissent, Justice Keene said, regardless of how the state chooses to label charter schools, the Charter Schools Act is clearly an invitation for private entities to contract to provide educational choices.
Another audience question, and maybe Alex, this is more to your side of the case. Person asks, focusing on describing a charter school as being a state actor seems to ignore the issue that the state specifically set up a program that allows private actors to tailor specific schools and curriculums to allow students and families choice and innovation. If, for example, other innovative charter schools are approved, including a progressive ideological charter school, and a religious school is denied, how is that not a hostility to and discrimination against religious families?
Sure. Let me address both those points. Thank you for the question. I mean, this charter schools were intentionally designed to provide kind of more experimental educational options while still providing a host of protections and accountability, protections to students and accountability to the government that don't exist in the private school context. I mean, if states just wanted to promote new kinds of education without doing those other things, they could just devote more money to private schools. And in fact, Oklahoma and a lot of other states have school voucher programs or similar programs like tax credit programs that do deliver a great deal of funding to private schools, and that religious schools can participate in those programs without making themselves subject to governmental requirements and thereby risking compromising their religious missions. I mean, charter schools intentionally are subjected to a whole host of requirements, including many of the core requirements that apply to traditional public schools, because the intent of the movement and the intent of the state legislatures was to maintain these schools as governmental entities that are ultimately beholden to the government. The sponsors of charter schools, such as the board here, is responsible for supervising and monitoring the charter schools. If the charter schools are not performing adequately, their charter can be revoked. And uh, no government officials don't have those types of control and oversight and power over over private schools. So, I mean, that's one reason that charter schools are governmental entities and state actors. With respect to the hypothetical of a school focused on transgender issues, I mean, that would not raise any kind of constitutional problems because the school, as long as the school isn't teaching religion. I mean, the constitutional prohibition of the Establishment Clause is that public schools must not favor any one religion or another, or push any particular religion on students. So now if the transgender oriented school presented some kind of religious teachings, for example, specifically attacking religious doctrines that are uh, in opposition to um, what they're presenting, that might raise possible constitutional problems as applied. But as long as if they're not getting into religion, then there wouldn't be an issue.
Another audience question. This would be a great First Amendment final exam question. It occurs to me. Person asks, can St. Isidore still rely on the free exercise clause in light of Locke versus Davie, which is the 2004 case from Washington State that held that Washington State could deny college scholarship program could deny recipients who were in pursuing ministerial training. So that's a 2004 case. So can St. Isidore still rely on free exercise clause in light of Locke versus Davie, which held free exercise clause does not necessarily demand that states fund schools on a religious endeavor? Is this sufficiently addressed or distinguished by Carson and earlier Espinoza and Trinity Lutheran? Phil?
Yeah, thanks. Great question. So in Espinoza, the court did distinguish Locke versus Davie as really being concerned about, funding of clergy, and distinguished a situation where there's funding of religious education, and said that when you look at history and tradition, there is not the concern with respect to education as there is with respect to funding. So then fast forward to Carson versus Macon. And again, Locke versus Davie is now really limited to just the situation of, funding of clergy. And Justice Breyer, in his dissent in that case, basically said, you know what, there's no play in the joints anymore. And that's true. Really, to be able to exclude a group based on their religion from a program that is open to secular entities, you have to have the Establishment Clause. I think the Oklahoma Supreme Court recognized that. Our friends on the other side recognize that. But this program in Oklahoma is entirely neutral toward religion. It doesn't favor charter schools that are religious. It doesn't it's not supposed to disfavor them. The board that approved the school didn't disfavor. And so it really has a neutral stance, or should have a neutral stance toward religion.
Do you agree with that, Alex? Do you think Locke versus Davie has been cabined into the corner of ministerial training, and that it doesn't apply in the Carson Espinoza context?
Yeah, it's we, at least in our briefing, we have not substantially relied on Locke versus Davie. I wouldn't agree that it's only applies to ministerial training. I mean, if it could apply in other situations where there's a important, longstanding traditional state interest um, in separating church and state. But we have not been relying on Locke versus Davie in this particular case.
Another question, can you speak more to the originalist arguments that each side brings? How does your side's interpretation of the founders' intent in drafting the Establishment and Free Exercise clauses inform your arguments in this case? For either one or both of you, want to speak to that?
Yeah, just going back to what I said about Espinoza, I think Espinoza really does tackle whether there are any Establishment Clause concerns about funding of religious education, public funding. And it distinguished Slack versus Davey because in history and tradition, the same concerns were not present. So I do think that it supports the idea that there's no Establishment Clause problem if you have a neutral program that is funding private operators of charter schools who have a faith-based program.
Yeah, I spoke about the original intent of the Establishment Clause in one of my earlier answers. So, I think it's very clear that the founders, did not want any government body, pushing religion on people in any way or preferring religion in any way. And as a public school, government entity, and a state actor, St. Isidore would do that. So it would be a clear violation of the founder's intent. Um, one on the free exercise clause side, though, I mean, one issue that really hasn't been paid much attention to in the recent Supreme Court opinions is, um, there's not um, historical evidence that the free exercise clause was meant to provide some sort of equal right to religious institutions to public funding. I mean, the free exercise clause was, intended to, prevent the government from, prohibiting, uh, particular types of religious worship or, stamping out particular religious entities. But I mean, this whole recent body of case law that has uh, supercharged the free exercise clause to bar anything that the Supreme Court views to be discriminatory against religion. Doesn't has never been tied by the Supreme Court to any writings of the founders or specific historical events that actually suggest that there's no evidence that the free exercise clause was meant to be used in this manner.
Okay, time for one more question. Audience member asks, how does the fact that children are not compelled to attend charter schools based on where they live, like they are with traditional public schools, factor into the arguments in this case?
Yeah, that's a great question because it really does show that there is no coercion of any child with respect to any faith. So our friends on the other side like to talk about St. Isidore's mission and their evangelizing mission, but it is a school that is one of many options. I think there are over 30 charter schools in Oklahoma, in addition, of course, to the traditional public school system. And so I think that just underscores, and it's a really important point, that there's no coercion of faith going on at all.
Alex, any thoughts on that?
Sure. So, once a student is enrolled in St. Isidore, they are coerced because they're forced to take theology classes, to take classes in which there's substantial integration of religion into the instruction, and also there's a requirement that students attend all school masses at least twice a year. Um, so, there could be situations where, parents might not fully realize what they're getting into, or students might be, you might not be consenting to, what St. Isidore is doing. And, as a governmental entity, um, it's still coercive and still a violation of the Constitution for St. Isidore to require these things. I mean, St. Isidore, again, they could be a private school that's not a charter school, like any other Catholic school, and then they would have their own freedom of religion rights to present the educational program that they choose. But once they become a state actor, they're governed by constitutional requirements. And like one other concern that I have is that if religious charter schools are allowed, you'll see more and more religious charter schools, and they might start. They'll end up taking money away from public schools based on how public schools are funded, and what we could see is religious charter schools displacing public schools, and then parents not having reasonable neighborhood options to send their children to a school where they won't uh, be subjected to religious instruction that they might disagree with. I mean, there's a school district, actually the Orleans Parish School District in Louisiana that is mainly composed of charter schools, and I believe only has two traditional public schools. So this isn't just speculation that this type of thing could happen if religious public charter schools are allowed, and that would be that result would be terrible for religious liberty if parents don't have reasonable options to send their children to a non-religious school, or have to like have their kids sent to a school really far away where they might not have transportation, or they might need to be bused just to get a non-religious education.
And one quick response to that, Michael. That exact argument was rejected by the Supreme Court in Espinoza. Basically, the Supreme Court said, look, if there's money that's going away from public schools, traditional public schools, because of this program, then that's the program. But it's not the fact that you have to open up the program to everyone, all the private groups, and not exclude religious schools.
Well, we are at the end of our time, and I'm grateful to our two panelists for this informed and spirited discussion, and to the Federal Society for sponsoring this webinar. And we probably have not heard the last word on this issue, and so look for future programming perhaps on this and related issues about religious liberty and education. But for now, we are adjourned. Thank you all.